Attachment of property. Let's break down the concept. When it comes to attachment of property, the power to attach property of any person should be statutorily provided. Means if the law is permitting an officer to attach a property, then only an officer can attach a property. Otherwise, he cannot attach a property. But basically, what do you mean by attachment of property? Means not to take over the possession of the property, even not to take the ownership of the property. Only right to transfer the property is going to be seized. Means if a property of me is being attached, okay, I would have no statutory right now further after attachment to transfer this property. I cannot sell out that property, I cannot lease out that property, I cannot mortgage out that property. Means all rights of my transfer would be seized by the authority. Is it clear? When it comes to attachment of property, this action is quite very common when it comes to Money Laundering Act, Fugitive Economic Offence Act, and Benami Property Law. So let's break down the difference between the attachment provision related with all three laws. So when it comes to Money Laundering Act or Fugitive Economic Offence Act, the power to attach lies with deputy director or any other officer who is senior to deputy director. Okay, but when it comes to Benami property law, remember the power to attach property lies with the initiating officer, who should be generally assistant or a deputy commissioner of Income Tax Act 1961. Got my point, students? Whenever an officer is exercising the right of attachment of property, first of all, whether it does require approval of the court or not, it doesn't matter. But remember that power to exercise attachment of property should be justified. Means the concerned officer who is exercising the power to attach the property should have reasonable cause to believe that the concerned person is being involved in that offense, and such property is the proceeds of crime. If in front of the court he would not be able to explain or justify the attachment, such an attachment will be treated as violation of his power, abuse of his authority, and that is not advisable, because he would be in a legal trouble if he would abuse his power. Further, what would be the period of attachment in case of Money Laundering Act and Fugitive Economic Offence Act is 180 days, but when it comes to Benami Property Act, it is 4 months. Okay, but when it comes to Money Laundering Act, the officer, that is deputy director, need not to take any approval before passing an order of attachment of the property. But when it comes to Fugitive Economic Offence Act, the concerned officer has to first take the approval of the special court, then only he can attach the property. And even in Benami transaction law, it does require involvement of approving authority. But here the approving authority's approval would be totally dependent. Means with the approval of approving authority, only the attachment order can be passed. Further, remember, if the officer would pass an order of attachment, remember that it is the duty of to present the case within the span of 1 month in front of the adjudicating authority, so that the adjudicating authority or the special court can verify whether the attachment was bona fide or not. Got my point, students?